this semester's third meeting of the Stead seminar on international comparative law. We're extremely fortunate to have with us today as our speaker, Professor Alexandre Alkmim Teixeira. He is a counselor at the Federal Administrative Council in Brazil, but he is also a practicing lawyer and a law professor. So you can see this from many angles, and we're very fortunate to have you here. Welcome to both.
Thank you, Tim, for the invitation. Hi, everyone. My name is Alexandre, and I'm here to talk about taxation with you. And taxation in Brazil may be quite a difficult and complicated issue, and let's know why. I'm, as Tim has already told you, I'm a lawyer in Brazil, and as a lawyer, I can also be a counselor at the Administrative Court of Tax Appeals. I cannot be a lawyer and a counselor, obviously. But I'll try to show you the view of the law by the lawyers and by the Administrative Council over the interpretation of the treaties we have in Brazil. But I would like to put it in a context in the first place. Brazil, as the US, is a federation. But we are what we call a federation of 3 levels, because also the municipalities are considered members of the federation in Brazil. So the union has the power reviewed in our constitution as the states, as the municipalities. And these 3 levels has also the tax power, the power to create taxation. We are a federation with 26 states in Brazil, and we have 5,570 municipalities. And each of these members of the federation can create its own taxes. We are from Belo Horizonte, in the middle of the state of Minas Gerais. Me and Marcelo Galupo came from this city. All the constitutional power in Brazil is previewed on the constitution. We have a written constitution with 250 articles, and all the power is described in our constitution. The tax power is, there's a specific provision in the constitution for tax power of each of the federation members. Each member has its power described on the constitution. But we have a problem. Not to be a big mess, we have a general rule that gives the structure of the taxes that will be created by each federation member. So the municipalities, they can create tax, but they must create taxes as the structure previewed on the general rule that we call general rule of tax. Also the states, they have its own power to create taxation, but to do so, they must obey the structure previewed on the general rule. And this general rule also gives solution for conflicts between the members of the federation in creating these taxations, in creating these taxes. And but this general rule it does not create tax. It gives the structure and solves the conflicts of power to create taxation. Each member of the federation, union, states, and municipalities has its own legislation, its own tax legislation. Until 64, from 64 to 87 in Brazil, and that's an issue that differs Brazil from the other part of the world. We had 4 species of taxes. We have tax, as you know. We have the fees, improvement contributions, and compulsory loans. These 4 species is what we call tax in Brazil. And its receipt goes to general expenditure. And we had as here, as most, as usual in the world, social contribution charge that is not tax, and it goes for the social security system. We had a problem in Brazil until '87. We were a dictatorship, and the central power, the union, used to use this social contribution for as taxes, use this social contributions for general expenditure of the government, and all the principles that were applied for the taxations were not applied to the contributions. So we had a hard work from our lawyers, from our professors, and from our deputies to change this. And we changed, transforming contributions on taxes in Brazil. So nowadays, contributions are a species of tax in Brazil. So in Brazil now we have taxes, we call tributos, and then we have tax with small t, fees, improvement contributions, compulsory loans, and special contributions. These special contributions, we have social contributions that are very similar to tax in the US. We have this special contribution named Stead. That's a contribution for economic purposes. And we have social security contributions, as that's what you call contributions and all. Stead and social contributions, normal social contributions goes to health or social assistance for others, and only the social security contributions goes to social security systems. So that's the scheme of how we deal with tax in Brazil. That's a little complicated if you put an international perspective, because when Brazil celebrates tax treaties, there's a general rule that the contributions are not supposed to be at these tax treaties. They are not be applied. These tax treaties do not apply for social contributions, because contributions goes to social security system. But when Brazil negotiates its tax treaties, we do not present contributions as a kind of tax. For the system of national accounts, what differs taxes from contributions are the origin of this charge and the destination of this charge. Contributions must be a charge derived from a relation, a labor relation, and it must be destined to the social security system of this employee. Tax, no, you do not have this relation of the labor activity or the labor relationship. And we have some contributions, that's the problem. We have some contributions in Brazil that do not derive from a labor relation, as we have also a contribution over income. So when you talk about income tax in Brazil, we are talking about, in fact, more than income tax. We have social security income tax.
On top of the contribution? On top of the contribution?
Yes, it's a type of contribution.
It's in addition to the contribution.
Yes, it's a social contribution, but as in your perspective, it's a tax. It's not a contribution. We call it a contribution, but the nature of it is the nature of a tax, because it do not derive from a labor relationship. Each and every company, even if you do not have any employees, you will pay this social contribution.
It's a non-labor based.
Yes, it's non-labor. Putting this in perspective, we have the main taxations in Brazil. I tried to translate to you what we have from what you have. Income tax in Brazil is taxed by the union, and we have income tax, we have this social contribution on profits, and we have this economic contribution over royalties. Every company who pays royalties abroad from Brazil are supposed to pay this city royalties of 10%. Okay, so when we say income tax, it's not just income tax. We have three types of income taxes. For the treaty purpose, Brazil only use the income tax, the first one. Generally, we do not present social contribution on profits as an income tax, and we never show city royalties as an income tax. We are having some problems with other countries in Brazil because of this. Because when the countries know that we have three types of income tax and we only apply the tax treaty at one of these three types, the countries just want to know why we have this difference and why we do not show social contribution on profits and city royalties as income tax. Our court has made some revisions and interpreting these tax treaties and has applied the tax treaties to this social contribution on profits. We do not have an IVA.
So what the effect of not applying the treaty is that Brazil will then impose those taxes
Yes.
The three parties.
without any limitations upon the treaty.
Yes, it's a treaty override, in fact. We're overriding the tax treaty. In fact, for the treaty purpose, it would be important that all taxation on income would be supposed to be applied with the tax treaty.
Does it make it hard to negotiate the treaty because
The problem is when we are negotiating the treaty, we do not present city royalties
No, no,
or
no.
social security on profits as a tax treaty. And if you read, oh, it's a contribution. Oh, it's not a tax. So you accept it to be out of the contract, out of the tax treaty. That's a problem of bona fide on negotiating the tax treaty.
I just noticed that you don't have an income tax listed for the states or the municipalities.
No,
Are
only
they prohibited from assessing an income tax?
Yes,
It's not true either.
yes. I know you have income tax from the states. We don't.
Or even sometimes in the municipalities.
Yes, we don't. Only the union has income tax.
Are there any sharing obligations with the union to the states or the states?
Yes, obligations, yes, but no receipts. The union receives income, tax income, and part of the tax income from the union goes to the states and to the municipalities, and part of the tax income from the state goes to the municipalities.
Is that required by the Constitution or is that
By the Constitution. You can always,
Germany's a little like that.
you can always have a voluntary agreements to share receipts, but the Constitution makes its own division. And at the end of the day, after this division of receipts of income from the three levels, union has something about 66% of all the income tax of that tax. And the states has 24%. We do not have IVA in Brazil. We have 5 taxes that rules what IVA does. We have an industrialized products tax, and we have a sales tax by the states, and we have a service tax of the municipalities. I call the attention for these 2 figures, COFINS and PIS. Both are also contributions. And they are contributions over revenue. And that's not quite common in the world. We have real estate taxation, union taxes, rural real estate properties, states, inheritance, gift, or succession tax, and municipalities, urban real estate properties.
I'm sorry, what does EVA stand for? What does EVA stand for?
If it's sales tax, the I
Like it's about your tax.
it's a VAT or
It's a national. Yeah, we call that a VA, value added tax or a VAT. Same thing.
VAT.
So it's a tax on
VAT on sales.
same thing as a VAT. How much is it? How much is the?
Oh, in this IPI, something about 10%. COFINS are and this are COFINS are. We have two ways of taxing these contributions. We have the cumulative and non-cumulative. The cumulative is COFINS is 3%. This is 0.65%.
Do any of these apply under either taxes to the end consumer, or are they just in the production stage?
Both.
Both? Do they apply to consumer as well?
The production is the IPI,
Mhm.
and the consumption is the sales tax, the IECMS.
Oh, that's right. I see. That's okay.
And
So that goes only to the states, not to the federal government. So the sales tax,
The sales tax is from the states.
and how much is the sales tax?
It
That varies by
varies
state?
from the product. You can go from 5 to 35.
That's interesting. You really have a VAT, this is interesting to me. You really have a VAT that is broken up into pieces. It doesn't work that way in Europe, where the VAT's, like German's VAT's collected by the central authority and then spread around the states. But you have a VAT that's broken up by taxing authority.
Yes, yes. And that's very complicated because we have a tax war in the states because of this ICMS, and we have a tax war at the municipalities because of the sales taxes.
Just a quick question. Your income tax rates, what are they?
We have two levels, 15% and 27%.
Is that for both individuals and
For
corporations?
individuals and corporates are 15 and 25%. We have three ways of the companies. We have three ways to calculate the income. We have the real income, what we call real income. We have presumed income, and we have the arbitration income.
And how does that work? I mean, taxpayers have a choice, or?
Yes, the legal way to know the income tax, the income is the real income, but you have an option to choose the presumed income.
Okay.
So, in this presumed income system, in service, 32% of your revenue is presumed as an income. Or if you are in industries or in the commerce, 8% of your revenue is presumed as income. It's a more simple way of taxation.
And then you said arbitrated as well?
The arbitrated is when you do not have the books.
Okay.
If you do not have the books, the accounting books, so you can choose the arbitration income. Okay. We have also taxes on payroll. These two contributions also are not for social security system, so they are not real contributions. They derive from the labor relation, but its revenue does not goes to the social security systems. And we have other taxes as financial transaction taxes, import taxes, and export taxes. And we have also lots and lots of other taxes as fees, as special contributions that are not here. Some studies point that we have something about 100 types of different taxes in Brazil. And that makes our life very complicated. As you know, it's very difficult in Brazil to deal with foreign investments and great economic difficulties. come from this extremely complex system, tax system we have. For international taxation purposes, we have international taxation since 1995. We started our taxation in worldwide income taxation using the residence principle, and we use tax credit as the unilateral measure to avoid double taxation.
So you tax Brazilian residents on their worldwide income,
Yes.
and you give them a tax credit. So it's very similar to the US.
Yes.
Unlike-
you in
unlike-
the US, you have residence and you have national principle also. Taxes
So it's
national
saying, yeah.
abroad, we don't. We just tax the resident reserve. And we have
If you tax them on the worldwide income, you give them a credit for foreign taxes. Right?
Yes, we do, but we use reciprocal provisions. We accept the foreign credit if the other country also accepts Brazilian credit. And to accept Brazilian credit, we goes to that previous problem. What is income tax in Brazil? It's just income tax, or the social contribution on profits are also income tax, and the city royalties are also income tax or not. So that's a huge fight we have in Brazil.
Yeah, but Brazilian citizens living in the US, as a resident of the US, are they taxed at all by Brazil then?
No.
If you're a resident of Brazil.
Yes, when you leave Brazil, you present a declaration that you're leaving, then you lose your residence. We do not accept it to lose your residence only if you move to a tax haven.
Okay.
Then if you move to a tax haven, then we do not accept the loss of your residence. Okay.
You might get into the weeds here, but do you limit the foreign tax credit? Do you base it on how much income is earned abroad times some rate?
We have limitation on the for the same income. We cannot use the tax credit for other incomes. So if some company has are taxed for an investment in India, for example, and the credit it receives is more than it will be demanded by the Brazilian government, you cannot use this extra credit
We have
for
this-
other purposes. We have limitation
And ask-
limited credit.
And how do you deal with a Brazilian company owns, let's say, a foreign company vis-a-vis Brazil? How do you deal with you don't tax the foreign company's income? You only tax it when it gets repatriated back to Brazil?
That's a problem. I'll get to it.
Okay, sure.
That's a
You
huge.
probably have two technical.
That's the biggest problem we have nowadays in Brazil is this taxation. We have only 28 tax treaties in force in Brazil. Why so few tax treaties? For political reasons and for economical reasons. Well, our tax treaties are this: Japan, France, Denmark, Spain, Sweden, Austria, Italy, Luxembourg, Norway, Ecuador, Philippines, Canada, Hungary, Turkey, Peru, South Africa, Mexico, Israel, Ukraine, Chile, Portugal, China, Netherlands, Korea, India, Slovakia, and Czech Republic. The last one was the Turkey tax treaty, which came in force in November of 13. And we do not have a tax treaty with the US. Why? That's a huge question, because we are the only country in the world with more than $1 trillion that do not, gross national product over 1 trillion, that do not have a tax treaty with the US. You have a tax treaty with all the countries, but Brazil with a national product over 1 trillion. And historically, the largest investor in Brazil is the US companies. And also, Brazil is the 4th largest investor in US Treasury securities. So we have a very, very close economic approach, but we do not have a treaty. And also participate in your stock exchange, and the Brazilian companies participate in your stock exchange, and it would be much more easier and much more logical to have this tax treaty. But we do have some points that makes it quite impossible for us to have this tax treaty. If you put in the pencil what each country would gain and lose signing the treaty, Brazil would have a great lose in revenues. Because the US model and the OECD model of tax treaty gives to the residence principle more value than the source principle. And as we have more Americans investing in Brazil than Brazilians investing in US, all the taxation would come to US, and none of them would be in Brazil. Despite of that, there are the taxes pairing provisions. What are taxes pairing? Taxes pairing are tax credits that are presumed for the taxpayers. And the provision of tax pairing are very discussed when you deal with royalties, when you deal with dividends, and when you deal with interests. Brazil do not sign tax treaty with developed countries without tax pairing provisions. And here in the US, you deal with tax treaty as a tax agreement, as an agreement, and you have a model of agreement, and this model of agreement prohibits the U.S. government to sign tax treaty with a provision of tax pairing. You are not allowed to sign tax treaty with this kind of provision. American government has already sent 3 requests for the Senate to ask this permission for Brazil to sign the tax treaty with Brazil, and the 3 times it was denied. But we have some evolutions in other aspects, as we have tax information exchange agreement in force since last year, since this year, since January. That's the first tax information exchange agreement signed by the US and by Brazil, and it's very important for us to have this first tax treaty, let's say, not tax treaty on income, but tax treaty on the exchange of information. That's an evolution. Some other aspects that are very important when you say in international taxations and tax treaties in Brazil. Brazil is not a member of OECD, and Brazil adopts some OECD's structures and some the OECD models for tax treaties, but with some reserves. And the importance of the commentaries are equivalent to the doctrine of Brazil. It's not binding to courts. We just take an account as advice or as an appointment or a doctrine, but they're not binding to courts. We are here, I'm here in the US, and I'm going tomorrow to Washington, that we have an International Association of Tax Judge meeting. And in this meeting, one of the issues that we will discuss is the dynamic approach or the static approach in the tax treaties. The commentaries of OECD rules are very important role and the interpretation of the treaties of the world. And we discuss in these commentaries, they are revised by each year we have changes in this commentary. And what we're discussing is if these changes on the commentaries should be applied to the tax treaties that were signed before the change has occurred, to give a static interpretation or to give a dynamic interpretation. Dynamic interpretation, as you, as a common law country, knows to use it more than us. You can have, you can adapt the interpretation of the real meaning the moment the rule is being applied. I know you have also some discussions in statutory interpretation, if you should give the dynamic approach or the static approach, and I've read some papers about the issue, and it seems that you prevail the static interpretation for statutory rules or statutory law. The static interpretation of the treaties takes into account the pacta sunt servanda principle. The tax treaty are negotiated by the parties, and the tax treaty takes into account the neutrality principle and reflects the reciprocity between the countries. When you sign a tax treaty, I don't know if everyone is familiar to it, we change, we specifically identifies kinds of incomes. Incomes from services, incomes from industrial production, income from dividends, royalties, interests, income for artistics, for students, and from real estate exploitation. So for each kind of income, you give the solution for the taxation. Each kind of income, you say you will prevail the residence principle or the source principle, and which state will be able to tax this income. So when you has a modification on the commentaries of the OECD models, you can change the meaning of the words that were used to identify which country will be able to tax. And so that's the issue, that's what we're discussing. If we'll have a static interpretation or if we'll have a dynamic interpretation. I've brought to you some positions of Klaus Vogel and Justice Graham Hill, here from the US, about to know if the commentaries are binding to courts. And of course, we have different approaches all over the world. Courts in Germany, Australia, Austria, Belgium, Canada, Norway, and UK accept the dynamic approach using the commentaries, although none of the countries says that the commentaries are binding to courts. They have an important rule on interpretation. And the commentaries are used in the dynamic approach from these countries. Most of the countries, however, use the static interpretation. We do not accept change of the commentaries for interpretation reasons. In Brazil, I had to present a case about this issue in Brazil, and I made a huge research over almost all the decisions we have in the administrative court and the judicial court applying tax treaties, and I did not find any discussion about it. Not a single discussion. I find 2 or 3 doctrines about it, but very small but not a consistent study or a decision saying specifically I'm using a static interpretation or I'll interpret the treaty using the commentary that was in force when the tax treaty was signed, or knowing that the tax treaty has changed, but I'm using it anyway. We do not have this discussion. I, in fact, found a case of Eagle. Eagle is a company in Brazil that is owned by the Ambev Group. Ambev Group is the owner of the InBev Group that has huge investments here in the US. Anheuser-Busch, Budweiser belongs to Ambev. And Ambev has this company in Brazil named Eagle, and this company in Brazil owns a foreign contract company in Spain, Jaguar, that owns companies in Uruguay and Argentina. And for tax purpose, the Eagle was taxed in Brazil from the revenues that were created in Uruguay and Argentina. And now, to understand this case, we have to understand how we deal with foreign companies' taxation. That's what you were asking. I think when we went to create the taxation of controlled foreign company in Brazil, someone in the Ministry of Finance asked the supervisor or the trainee to search in Google how countries deal with controlled foreign company taxation. And someone wrote controlled foreign company taxation, and they found the CFC measures, tax avoidance measure, tax avoidance model of legislation from OECD. And that's what we use as a rule. Never knowing or if it's a tax avoidance or no, we tax all the controlled foreign company investments and revenues in Brazil in the day of the end of the year, even if the profits has not been delivered, even if the dividends has not been paid. That's the general rule. And that's a huge problem, because if a foreign company comes to Brazil and asks me, Alexandre, I would like to have a holding company in Brazil to deal with my investments in America Latina, I'll say to him, do not come to Brazil. Because all the foreign company, controlled foreign companies' profits at the end of the year will be taxed in Brazil. That's how we do it. That's how we deal with foreign company taxation. That's madness. That's madness.
Do you have an inversion problem then? Because that would be even worse than here. So what's happening in the U.S., and Catolica can speak to this better than I can, is that U.S. corporations are changing their status of the parent corporation to a foreign country to avoid U.S. tax on foreign earnings. In our situation, it's more people over yours. So I would think you wouldn't want to have a company in Brazil to begin with, any scope in Brazil at all. You want to, if you were an international business, you would want to be centered outside of Brazil.
Yes, outside.
And just have a subsidiary in Brazil to cover your subsidiary.
We have some big companies. That's Vale. It's one of the biggest mining companies in the world. They had this in Brazil, and Vale had a tax assessment of over $1 billion. $25 billion, something about 5 billion reais, just because of this.
They move their residency then to
Not yet, but
they're fine.
I don't know if they are planning, but there is no much point in staying in Brazil. As you will be taxed at the end of the year from the revenues that you have not received. And
it might be mitigated somewhat though, because our highest rate is 35%. Theirs says 27% for corporations in Brazil. So it could be there.
Well, that's not enough.
the problem,
Well, no, but I'm saying if they're investing, if these subsidiaries are in countries that are in fairly high tax rates anyway.
the problem
It's
is
a credit, yeah.
this this companies, these contract foreign companies, they have not delivered the profits. So you do not have the tax credit. You do not have the tax credit.
Oh, you don't get the tax credit?
No.
That's silly.
No. You do not have the tax credit because it's not being delivered. It's not being
Under our
it's
system,
I try to find the best word. I don't know if it's assumed distribution of dividends or presumed distribution of dividends, but that's what we do.
see, on our system, we have a scaled back version of what you do. It's only sort of income that is viewed as being put in the foreign subsidiary for avoidance purposes, although there's objective tests. But once the income is deemed to be distributed, then you do get a foreign tax credit on those amounts.
We do not have this provision. We just we have to prove the payment to get the credit. And in this case, we have a presumed distribution of dividends, so you cannot prove the payment.
Right, but the foreign subsidiary, if they show that they made the payment of the taxes, that's not good enough.
They made the payment of the tax of the
Right.
tax to that company, to the source company.
No, I'm saying that your foreign subsidiary has earned some profits, right?
Yes.
They paid some taxes to some other jurisdiction, right? And the foreign subsidiary can prove to the Brazilian government that the taxes were paid, but still the credit will not be allowed.
No.
If between states, let's see, Maryland and another Brazilian state, they made a treaty for exchange of knowledge and information, is that any tax break for the foreign company if they open a subsidiary in Brazil?
You can work in Brazil as a non-resident or as a resident. If you're a company, right? Okay. If you're a company, you can work as a non-resident or as a resident. To work as a non-resident, you have to have permission of the Brazilian government. And as a non-resident, you will be taxed on 25% on gross income.
Okay, but more?
No.
No.
25%. If you have a subsidiary or a contract foreign company in Brazil, or you work as a company in Brazil, you'll be taxed in as Brazilian taxation, income tax. It's lower in the end of the day because you have the income found by real income or presumed income and not over gross income.
So the state treaty wouldn't be.
I don't know if Brazil signs sign treaties with states of Maryland, for example. We only sign treaties with the United States. Okay. In this case, we were discussing the nature of this presumed dividends. If they are dividends or if they are not dividends. If they are dividends, we go to Article 7, that taxation of dividends shall be taxed in both countries with a limitation of 15% in Spain. And if it's not dividend, it's profit, it's income, then we will apply Article 7. Income is taxed only in Spain. Profit of an enterprise of a contracting state shall be taxable only in that state, if not permanent establishment. And that was curious because we do not have any provision on the commentaries, and we even did not have any commentaries when this tax treaty was signed. And it was signed in 74, enforced in 78, no commentaries at that time. And that's interesting because the model of 77 introduced the Article 10.5, and this Article 10.5 shows a concept of undistributed profits. So what happened in this case is that the counselor responsible for this case used this undistributed profit concept to identify if what we do, this presumed dividends in Brazil, if they are the same of this undistributed profits. We used the new commentaries at the time that did not exist at the time the treaty was signed to interpret the tax treaty.
You're distinguishing distributed profits from dividends?
Yes.
That's what the dividends in this country are basically distributed profits. So
We did not apply this provision, but we used the same concept, the same logical to identify if
how do you define a dividend? I mean, in this country that wouldn't make any sense. I mean, that's not how we define dividends basically as distributed profits. So
yes,
it would make sense.
dividends are distributed profits. So the article says about undistributed profits. Taxation of undistributed profits.
It's
Undistributed.
Oh, I thought you said distributed profits. Oh, okay. Oh, I see. Undistributed. Oh, I'm sorry. That makes more sense.
And we had this decision, and the councillor said, I appeal then to the considerations contained in commentary that number 5, article 10. This number 5 does not exist in the treaty with Spain because it's prior to the writing of the new model of the commentaries. And knowing that the commentaries did not existed when the tax treaty were signed, she used this commentary, this new perspective, this new concept to interpret what we have in our legislation, that this presumed dividends. And I think it may be considered a light, dynamic interpretation of tax treaty result. It's interesting when you take the decisions, when you take the cases, and even those that use the commentaries, we do not make any reference of when the tax treaty was signed and when the commentaries were published. We do not have any reference to it. The only reference I found in all the decisions I got to is this case, this single case. So the decision took into account the provision of the model that did not even exist when the treaty was signed. Okay, that's it. I thank you very much for the invitation and for the patience of it. Thank you.
This has worked well in the sense that we've had an opportunity to ask questions as we went along, but I think we should also give an opportunity for questions that may remain, if there are one or two at the end. Does anyone have anything that they want to ask Professor Alkmim in the light of what he's just said, now that he's completed his remarks?
Well, I have just, I'm sorry.
No, please.
Well, these are very general questions, so as a policy matter, I mean, what do you think is the better approach? A dynamic approach or a static approach?
We had a problem in Brazil now with Finland. That's not our Internal Revenue Service made an interpretation of the treaty we have with Finland in a dynamic approach. And Finland questioned Brazil why we were interpreting that way. That's not they had negotiated, and if we do not change our position, the treaty would be denounced. So I like more, let's say, the dynamic interpretation. I think it makes the rule alive, and I like that. But when you deal with treaties, you should have bigger cautions, let's say, because it may not be what the other state understand about the treaty, so you will create a problem. I prefer the name interpretation, but I think both countries should sit and discuss if they will or not use the new commentaries. When you say it's a tax treaty between two countries that are member of OECD, it's easier, because as member of OECD, both of them are to the OECD structures and advices, let's say. As we are not a member of OECD, it may be a little more complicated.
Professor Peters.
Yes, just a question or two that reflect my ignorance of the whole subject. I'm much less ignorant of it now than I was 45 minutes ago, I think, because I'm not. So the commentaries on these treaties, where did those come from?
From OECD.
Okay, OECD is, pardon my ignorance, what is OECD?
At the end of the Second War, the Second World War, it was created an organism, international organism, to rule the Marshall Plan
Okay.
for the reconstruction of Europe.
Oh, okay.
It was named European, let's see,
Organization.
de Cooperação Econômica Europeia, European
Okay.
Economic Cooperation Organization. And it was formed by US, Canada, and the European states. When the Marshall Plan ended, they transformed this organization into the OECD, Organization for Cooperation and Economics and Development. What it was thought is that we have ONU, UN, United Nations, but United Nations are for all the countries. In OECD, you have the rich countries, capitalist rich countries at the end of the Second World War. So Japan, Australia, and New Zealand joined OECD, and it became an important organism to study and to uniform the political economic relation between the countries, between the member countries. It gained importance over the years and started to deal with tax issues to identify how the countries should deal with tax avoidance and tax evasion, mostly. And on the other hand, we have this model of tax convention. In '74, I think, we have the first draft of tax convention, and then we have the first model at '77, and then they started to write commentaries. There's a committee in the OECD that reads commentaries on the OECD model.
On the model. The commentaries take account of
How should which are the alternatives of writing the tax treaty and the when negotiating, and after the tax treaty is signed, which are the possibilities of interpretation of the tax treaty.
Do countries have a veto power of those kinds? Like, can the US veto a commentary?
Yes, we can.
So
Also,
veto
the state members can, and we are listeners. We get to know what your OECD are doing. We do not vote, but we can say, I will not use this.
So the US could, for example, say, if the OECD wanted to adopt a particular commentary, the US could just veto it, and the OECD
Yes,
no, no.
yes. US has its own model. US do not use the OECD model.
Right. We don't follow commentaries. I'm pretty sure we have a static approach.
Right.
So every time a treaty
It would be a huge problem for us.
right. So every time a treaty is issued, we actually have our own edition called commentary that comes out. So the Treasury Department and the Senate Foreign Relations Committee, they put together reports that serve as like legislative history, or more like regulations almost, that elaborate on the terms of the treaty.
Have you got a commentary on your own?
I'm sorry?
Have you got a commentary on your own model?
Yeah, the
At the
The,
moment,
tre-
it's-
the model, the Treasury model has a commentary. It's actually the technical explanation put out by the Treasury Department. So it serves as a commentary on the Treasury model.
Do countries that enter tax treaties ever specify in the treaty whether they will accept subsequent commentaries as interpretations of the treaty?
No,
That's just has not been done. But
I don't know.
is there any
because
reason
of
why it
this
could not
provision.
be that?
That's because the commentaries are not binding. They are not obliged to obey the commentaries.
But it could make them, in a sense, binding to the
Yes, but
countries.
I don't know. I think anyone has done it.
So you bind yourself to something.
Exactly.
Is there some sense that the commentaries have some political valence, or that they serve the interest of a particular group of countries?
OECD has prefers the residence model, the residence principle of taxation, taxation by the residence, than the taxation by the source. Developing countries and underdeveloped countries prefer the source principle, and the developed countries prefer the residence principle. As OECD represents the developed countries, it prefers the residence principle.
Well, I think this has been an extremely helpful and enlightening talk, and we're very pleased to have had you here at the University of Baltimore. Thank you for your remarks.